Patents could be a poison pill in an early stage company. Hello and welcome back. This is John Cronin, Invent Anything. Are you keen to understand what a poison pill is, what the stakes are in a startup world? Whether you're a CEO, an investor, or part of the management team, you will discover the insights that could make or break your company, truly. So discover the importance of patents as a strategic asset, but learn how to shield yourself from the poison pill.
Inventions keep the world spinning. From fire in the wheel to today's high-tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
In this episode, we will cover 6 different areas. In topic number 1, we'll cover the background of what a poison pill is. In topic number 2, we'll talk about some case studies, the results of a poison pill in a company. In topic number 3, we'll talk about the patent management challenges this brings, which will then lead us to topic number 4, the strategies for managing patent disputes, various roles and responsibilities, and what they can do. In topic number 5, we'll talk about the ways to fix the poison pill issue if it happens to you. And topic number 6, we'll talk about future considerations, and then we'll wrap up. And thinking about the audience, it's kind of interesting to think that there may be those that have no clue what the poison pill is. And I got to admit that this poison pill is a concept, the name, the catchy phrase, I guess, it comes from us. But it's something that is fair warning to any small companies. So you should be interested in this podcast. A second audience we think are those small companies who have gone through or are going through a poison pill issue. This is certainly true for you because there's some key insights that will help. In topic number 3, we'll talk for the investors. What does it mean to the investors? We believe the audiences are investors who are key to know the diligence they need to do and how to deal with the issue. Another audience we think is the management of supervisory levels that may want to get a briefer on a poison pill. So in a forward way, they can think about the things that they need to do to protect the company. Of course, one of the audiences is definitely the CEO. Having been a CEO myself of 4 or 5 companies I've created, I can tell you this actually happened to me. So I became very well aware of the issue in very early stage companies. So for CEOs, definitely this podcast is for you. And finally, one of the audience, we think that for those trying to resolve a poison pill issue, an audience we think that might benefit from this is those teams that try to resolve the issues between legal, the marketing, the product, the management, the investors, and the board. So this is also for you. So this is John Cronin from Invent Anything, and would hope you stay tuned for the essential guide on navigating the startup world in these patent poison pills. We're going to learn how to uncover the strategic patent management problems that's crucial for the downfalls. We're going to learn about the turmoil this causes, and then we're going to discover some proactive steps to the poison pill. And we're going to have really an eye-opening journey for how a startup can survive in this early stage and avoid the patent poison pill. So let's go. Topic number 1, the background of the poison pill. First of all, what we might call an innovation linchpin. Patents are a vital part of startups for protecting their proprietary technology, and many times they help you drive the market. But there's the strategic shield aspect. Patents safeguard against imitation and legal disputes and secure startups in their market position and growth. But patents are more than that. They're more than just defense. Patents are key for licensing opportunities, capital acquisition, enhancing M&A value. So they're not just for litigation protection. But here we come to the poison pill issue. Poor management can lead to internal conflicts, legal issues, loss to investors, and this is known as the poison pill effect. This could be, quote unquote, a CEO catastrophe. Mismanagement of patent assignments can result in a CEO-led bankruptcy, and it can cause a lot of strife for companies. One of the catches is that it's a neglected inventor nightmare, meaning by overlooking the contributions of co-inventors in a company and then overlooking their assignment of patents can cause severe repercussions. What about patent pitfalls here? Inadequate patent administration can lead to significant legal and financial consequences for startups. There's some cautionary tales, of course. The importance of effective patent management will be highlighted through some real-world examples we'll give you. But really, it comes down to how the CEO is going to set this up and face these outcomes if it happens. Which comes to sort of a background, the proactive strategy need, that startups may employ proactive approaches and seek the legal expertise they need to perfect it, so they don't have the detrimental effects of the poison pill. I just got off the phone with a startup. We deal with about 20 or 30 a month in IP Capital Group. And one of the first pieces of advice I gave them as they're about to bring their team in to talk about inventions is to make sure you have assignments because of the world of the poison pill. And then finally, one of the things that we can do is take a look at a comprehensive analysis that we can take an in-depth look at sort of how these poison pills actually start. And it's much more than just getting assignments and inventorships right to avoid poison pills. So we'll delve into that. But first, let's get into topic number 2, which is some case studies. These come from real examples that I've worked on. And by the way, there are many examples of this, many, which is the reason why I decided to do this podcast was because I started to see this more and more. And I said, it should be of value to the people I work with to understand this patent poison pill and take it seriously. So we'll talk about how mismanagement led to these really big problems. We know that, as we said, that patents are really important for licensing, for proprietary, ownership, etc. But mismanagement can lead to lots of things. So let's talk about a case study number 1. A CEO fails to assign his patents to the company, which then leads to issues when the investors want to do something with the company and the investors want to guide the CEO to do certain things. The CEO doesn't want to do what the investors want. Normally, an investor would know that they have power over the CEO because the CEO works at the pleasure of the board of directors. So the board of directors gets sort of crosswise with the CEO and tells the CEO no uncertain terms that he has to move the company a certain direction. CEO then pops up and claims that he owns the legal right to the patents, that he hadn't assigned the patents to the company. What this did is lead to a lot of problems because he decides to leave and the company's now sitting there with maybe a new CEO, but they can't launch the product because there's a patent dispute. And eventually this unresolved patent assignment leads to lots of legal issues. It culminates in the company's bankruptcy. And it illustrates to us how investors really need to understand the assignment of patents. In case study number 2, we have a CEO that has a co-inventor who basically, the co-inventor wants to get stock and equity more than he has because he's contributing to an invention. The CEO says, "The heck with this. We don't need you to have this assignment." And what happens down the road is that this co-inventor doesn't get any more equity or stock. But then the patent issues. And then the company needs this patent to go into the market. Now the co-inventor, because there was no assignment, could claim that he's an inventor. And more importantly, he does claim he's an inventor. And because there's no clear inventorship, now the patent is problematic. And resolution of this problem came with the CEO have to literally give the co-inventor employee more stock and more equity than he had to do. And as a result of this problem, the investors and board basically downrated their belief in the CEO and asked him to step down because the CEO thought that he could say who was the inventor and who wasn't. You see, inventorship is a legal determination by patent counsel by looking at the claims of a patent and the contributions to those claims of the patent. So the CEO could be to blame. In the third case, a CTO was fired. And basically, the CTO went off and filed some patents after he left on the product the company was working on. The startup company didn't have proper assignments. So the fired CTO got the patents. Then a letter from the CTO to the company, to the board, says that they can't, produce their products because he owns the patents. A legal battle comes in and there's huge disruption to the company, huge financial losses by pushing the product announcement out. And what happens at the end of the day is the company ends up in distress. These 3 case studies represent to me things that happen a lot in early stage companies without proper assignments and inventorship. But as we're going to learn, it's much more than that. So coming up, we're going to unlock the secrets to what we can do from a patent management perspective that's essential for eliminating this patent poison pill issue. We'll showcase you how to avoid the common pitfalls. We'll talk about how you can avoid jeopardizing the startup company's future. And don't miss our highlights about how CEOs should work, how boards should work, how investors should work, and even how management should work. So stay tuned. It's a must watch for how to take the next steps for patent poison pills. A little bit of background. As a result of the insufficient resources, many times of small companies, and lack of expertise in specifically patent management, many early stage companies make the mistake of not taking action here. I would say that one of the first things any startup company should do is to understand this one issue, because a large percentage of startups enter with this problem or don't get funded because they have this problem. One of the things that's really important is the necessity of expert patent counsel. See, patent counsels are patent counsels. They don't manage the business. They don't manage the market or the product direction. They don't manage the personnel, but they certainly can tell you about the documents you need, the assignments, the NDAs, and inventorship. So working with that expertise is important. Avoiding it because you're thinking you're saving money is a costly mistake. The next thing is overlooking patent due diligence. If you're a CEO starting a company, or you're a co-founder, or you're an investor, one must take a look at the ownership of intellectual property. One must get each inventor or employee to sign off that they own that they don't own the rights to their inventions. It's assigned to the company. A lot of times there's oversight here in not doing patent due diligence. So one of the high recommendations to overcome the poison pill is to do proper patent due diligence. One of the things we see, and this is the 4th thing, is there's many times handshake deals amongst founders. I can't tell you how many times this happened, and it happened to me. So often startups begin with sort of informal agreements between 1 or 2 people called founders. Together they want to conquer the world, but as they get going and start to raise money or get in the middle of raising money, they fail to formalize this relationship in written patent assignments. And then this later on can lead to disputes, like we talked about in case study number 2. And what happens is, as the company grows, this problem gets leveraged even more because those who have not assigned have more leverage because there's more money. One of the things that happens quite a bit is the companies bring in consultants. I, as a consultant to many companies over the years, thousands of companies, I guess, we always want to make sure that we have our NDAs in place, our proposals in place, but we also do an assignment right off the bat. So our client companies know if we come up with anything that we're assigning it to them. So hiring consultants to do prototypes is clear, or any kind of consultation. It's really important to add to the proposal the assignment of rights. I can't tell you how many times I get a call from a company where the consultant will not assign rights and won't do that up front. And they don't understand why that would happen. Well, it's because consultants like to own their intellectual property as well. So consultants' involvement with patent assignments is critical. One of the things about CEOs in general is hiring practices. When they inadvertently hire people for even a short time on a trial basis and not have assignments in place can pose a real risk. These individuals that work for the company can gather insights to lead to filing patents independently. So it's important to do rigorous background checks on people and make sure you get the clear assignments. Look, if you do a background check and find out that this new potential employee has already been in a poison pill situation with a dispute in another company, stay away. One of the things that happens a lot is that the company will discuss unpatented products without NDAs. So now the poison pill can manifest itself by someone you talk to that claims that they own the invention, because in first to file world, it's first to the patent office. So NDAs can help there. Certainly you can't get someone you're just talking to assign ideas, but you certainly can get them to sign an NDA. One of the things is ignoring totally this first to file rule in the patent office. There's many cases by which an individual with a company, just even in an interview with the company, goes off and files patents with the patent office. So it's important to understand you may own some rights, but it's still first to file. So proper patent assignments, inventorship rights, to be clear, but also understanding the velocity by which you need to file your own patents. And then I've seen this quite a bit, that people will get online and try to save money by downloading from some website general assignments. This is kind of crazy because these general assignments don't cover the specific natures of what you do, specific timeframes, and specific different rights. For you to practice law by downloading general assignment forms is totally crazy. You know what they say about a person who represents themselves, right? So the idea would be that don't go to these general places and download forms. Please get legal counsel here. And I'm not a patent attorney or an attorney, but you know, I've told many CEOs one of the first things they have to do is to get that clear. There's other things we're going to talk about in the organization you need to do, but certainly these assignments make a lot of sense. Let's go into topic number 4, strategies for managing patent disputes and sort of roles and responsibilities. Now, in almost all these cases, I've held these roles myself. I've been chairman of boards, public and private, board members, advisories, CEOs, CTOs. I had a lot of different roles in different companies over the time. So let me kind of give you different points of view of what these different entities, viewpoints would do in a company. So one of the things as a board member, if you're a board member, is to make sure that you're an advocate for getting clear patent policies and also to regularly audit them with the company. It's not enough to just put it in place and walk away. So generally, there's a committee formed in a board that deals with material facts of intellectual property. So that would be the committee that would make sure those policies are in place. An ounce of prevention is worth a pound of cure. Another thing is getting legal guidance for board members. Encourage that the board itself gets an understanding from patent counsel of how to guide this issue. We understand the CEO's job is to do that. I would also suggest that the board get the same information. One of the things is that when there's a poison pill issue, there's almost always some sort of mediator brought in because there's always some problem associated with how the company treated somebody. Think about it. A happy employee that loves their job and wants the company to be built would absolutely sign in the assignment or inventorship document, correct? So it's the ones that won't. There's something else involved. And that something else really is a non-legal mediator. To bring in a legal mediator with an issue like a patent poison pill is going to make it legal right away. And so the idea is to bring in some other kind of mediator, some ombudsman for both the company and that employee. One of the things is that, you know, there's this sort of stakeholder-centric decision-making that boards make, where they're trying to make informed decisions about the legal issues of a poison pill. But one of the things is they're trying to consider the impact to all stakeholders. I'm in a company right now where the board has ruled on a couple of things, but by publishing their decision-making to the stakeholders, the investors that are not on the board, leads to the board being now crosswise with stakeholders or investors who don't believe they're handling it correctly. So I can't recommend more that a board would go off and talk to its stockholders before it makes any kind of strategic recommendation on some sort of dispute with a poison pill, because it affects everybody. Let me talk to investors for a minute. I talked about due diligence. Certainly patent due diligence is something you always think about. But, you know, I've worked for countless investors, hundreds of them, and very few of them will ask me about this issue of inventorship or assignment. They'll ask me for clear title on patents, but they won't ask me if there's other potential inventions that could be patented that could have a patent poison pill. So investors need to do their intellectual property diligence, but add to it all the things that surround this patent poison pill issue. A big thing for investors is to make sure there's proper governance on patent poison pill issues, making sure there's clear policies, as I mentioned, with the company. But governance by investors is more than just setting it up. They need to monitor it and come back and see, you know, and maybe ask for a report. Generally, investors get a quarterly report, at least from the company. And one of the aspects of that quarterly report should be assignment and inventorship. One of the things is that we can take a look at investors in it, and sometimes they can play a very unique position in a patent poison pill issue, because investors want the best for the company, but a lot of times investors who want the best for the company really clearly understand that the company is its people. And if there's a dispute over patent poison pill, it means it's probably a person dispute. And so the investors playing the ombudsman, because they only want the best for the company, can many times resolve some of these issues by maybe making some move have the CEO provide a raise or some more money because the employee was overlooked, or maybe provide more recognition because the patent poison pill issue resolves around recognition. And that's not a legal issue, right? This is sort of an ombudsman approach. One of the things is that the investors need to continually reassess the patent poison pill issue, because sometimes it can happen in the mid-size of the growth of the company, not just at the startup side. One of the things is that the CEO clearly is upfront on this issue. They're kind of the pioneer for figuring out what to do about this. And if the CEO is fair and is pretty rigorous about not bringing on people without assignments, and doesn't allow this inventorship issue to bother them where they have to make the decision of inventorship issues, can really guard the CEO's position. And one of the things that the CEO should do is have clear education policies about inventorship, what it means, and why they need to sign, and why this needs to be done routinely. Some companies have inventor notebooks, for instance, to keep track of the inventor's contribution. Some companies bring us in to do an IP extraction every quarter so that they can very clearly know what inventions are there and what are owned by the company. You see, when the CEO doesn't really know what inventions are owned by the company, he leaves him or she leaves himself open to the poison pill. So coming up, tune in for more stuff on the poison pill trap. And we'll equip you with now strategies, creative resolution strategies for de-escalating these poison pill disputes. Learn how we can safeguard your innovations and be vigilant about the poison pill. And for CEOs, learn how to gain some critical knowledge with these issues. And then even more importantly, join us when we start talking about the delicacies of the creative aspects of getting yourself out of a poison pill issue. Let's get into topic number 5, strategies for way of fixing the poison pill issue if it happens to you. By the way, I'm going to give you some points. They're not exhaustive. Everything depends upon the situation you're in. So bringing in some expert advice might be also wise, who have dealt with many types of situations, and understand it from both the legal, market, business, product direction, from the investor and the board direction, because all of those have an axe in the fight. The first thing is on emergency response awareness. If it happens where you get a letter or there's a threat of a poison pill attack, meaning I'm the inventor and you don't own the rights of something your company really needs, one of the mistakes I've seen is very quick reactions. In other words, the CEO or a board member taking an absolutely authoritative reaction and coming down like a hammer, thinking they know the answer, put employee in their place. Well, let me tell you, that doesn't work. It might work for the short run, but then later on, you will find out that you're going to get a letter from the lawyer of that employee. And then all of a sudden, the curtains get drawn and you're in a legal dispute. So one of the things is to be thoughtful. Do not have an emergency response. Put it on hold, get a lot of advice, and then make a decision from there. One of the things I've come to recognize is experience is really important. We were recently in a case whereby we were able to have a disputed invention. And with the disputed invention, we basically, because we didn't have the inventor sign off on it, we sent it back to the inventor, the one who claimed they were inventor. And before we even responded about whether they were an inventor or not, we just asked them, please read this and tell us what contribution you made. Huh, that's interesting. So before we're even arguing with the point, we're asking this potential inventor, well, what contribution did they make? That would be a reasonable thing to do. And if the inventor comes back and makes some contributions and say, this is what my contribution is, we can look clearly at the patent and say that the claims that we resolve to that contribution maybe in the patent, or maybe we don't want to put them in the patent. We can eliminate those claims. There's so many different things we could do here, but if we're patient and then we get data, we can have a experienced response. I've mentioned this a few times, and I don't want to be negative about legal counsel. They're absolutely required here, but bringing in legal action tends to intensify the conflict. So there should be someone that's thinking about bringing in legal and bringing in a board member and bringing in a stakeholder or whatever it requires, but someone who's thinking about this more as a sort of ombudsman role or some sort of mediation role, because many times these things are solved by just a conversation with a listening ear. There's also sort of understanding a holistic strategy here. You see, sometimes you can have an issue of a poison pill on a product, but maybe you could go to your vendors team and invent around that patent that's of issue and modify the product a bit. Maybe that modification and small change won't even be recognized by the customers, but you can sort of take the rug right out of the whole issue. That's part of a holistic approach, understanding the impact of the product or the technology. Another impact of the approach could be thinking about investors. See, if investors really are ready to take on the fight, then maybe you shouldn't be wary of taking on the fight. Because keep in mind that a rogue employee that claims they're an inventor and won't sign an assignment will not have the amount of money to fight against a company. And most patent attorneys I know, or attorneys, would not take this up as a legal case on consignment, on contingency. So, holistic approach, think about the whole situation. Sometimes a unique solution is found that could require some tailor-made situation. The employee was going to retire anyway, so you pay the employee early retirement in exchange. A lot of times when employees leave a company, when you want to sort of let an employee go, you'll probably offer them some money where they'll sign off all their rights. So it's that same concept to maybe move a poison pill inventor out of the way. Maybe what they want is just, a little bit of money for their belief that they contributed. Another area is sort of expertise acquisition, whereby you're trying to manage a situation, but you're trying to understand its impact in time on the business. So if a poison pill issue comes up very early in the company, it's not going to impact much about the product direction, technology direction, how we're going after customers. It might impact the financing. On another hand, if a poison pill issue comes up right before a product launch, that's a really big deal because that could hurt the company by stopping the product launch. So when you're acquiring information about the poison pill, understand the timing of it. Another thing about all kind of disputes is de-escalation, to try to find a way to de-escalate the situation correctly. And that means maybe doing some legal work, but also some sort of HR work. Another area which I tend to enjoy is solving the problem with inventive problem solving. So I have a poison pill issue, which is all about some invention or a group of them, whereby there's not proper assignment made, or someone now claiming they're inventor. Well, doing an analysis of those inventions could many times lead to, if we could invent around those patents, we could come up with some new inventions and not even need these inventions and take them off the table. That would be a wonderful way to resolve the situation, because chances are the inventor round might improve better inventions. We always recommend in our practice in IP Capital to do inventor rounds of your own patents even before you file them. But here, clearly, an inventor round is one way out of the issue. But there are many other ways that inventors can help with that issue, maybe modifying the product, etc. So clearly bringing in the inventive mind into the poison pill would help any CEO deal with that issue. One of the other things we can do is do a comprehensive analysis of the situation to see if there are other underlying issues. I mean, yes, the poison pill inventor didn't assign. Yes, the poison pill inventor was doing it for some reason. They're not being awarded enough. And yes, the company's method of dealing with intellectual property is not, what it should be. But a comprehensive analysis further might find is that the hiring practices of the company are such that it's hiring the type of people that might be the ones that would be more inclined to think that everything's their invention and then want something for it. So hiring practices certainly can help you with that, because those type of people, not that we dislike these type of people, they may be better off starting their own company, having the ego that you're the inventor and you're making the maximum contribution may be a telltale sign of hiring practices. So doing a comprehensive analysis is really important. And then, as I mentioned before, don't react quickly, but be proactive. In other words, if you even suspect that this is about to happen, test the waters really quickly. If you didn't have the assignment in place and you suspect it, the earlier you could get a discussion with a person about they need to sign their rights as a matter of employment, the earlier you can do that, the better. In the case of one client I'm working with, they waited just too long. They waited for a couple of these employees to get a positional power in the company where they could influence the board. And now getting them to sign the assignment was very difficult. So let's go to topic number 6 on future considerations. The first thing is this idea of ensuring that management create the safeguards and steps to have patent assignment and inventorship defined on the front end certainly is a future consideration for any company that's going to get started. Another thing is to try to look at this inventorship issue and clearly get an understanding that patent counsel makes that recommendation. CEOs, boards, you don't. And this major misunderstanding could actually think you're right. And then you'd end up in the patent poison pill. And it really wasn't any problem associated with anything except the CEO or the board or whoever making decisions thought they knew what inventorship was, and they clearly didn't. And that's the problem. So, and don't look up online what inventorship is and think that you know what that is. You should bring in patent counsel to do that, because that's a legal question. One of the things is that when you take a look at this in the future, having some wisdom here of sort of the holistic view of the people and the product and the market and the assignments and all that legally, that provides a lot of wisdom for the company. And that's the reason why many times people hire experienced CEOs because they have that wisdom, right? They've had the problem, and therefore they don't want to have the problem happen again. But, I've seen CEOs join groups of other CEOs where they could talk about such issues so that they could kind of nip these problems in the bud. And so hopefully even this podcast would be something that if CEOs watch it, it's kind of like getting the education and planning for the future. One of the things is that in the future plans of the company, thinking about how NDAs are used. Certainly lots of companies have NDAs. A lot of them just think they're a formality. A lot of people don't use NDAs the way they're designed to be used, which is when you have a confidential discussion, send a memo that captured what the confidential discussion was to clearly understand what your inventions are before you get involved in an NDA, to disclose in the NDA the inventions you had before the meetings. All these things are ways to stop the patent poison pill. Another thing is that, managing talent is really important. So the crazy thing is that you can get more help and more support by recognizing inventorship in the company and making that a big deal. Because if you make it a big deal that these inventions are really important to the company, which they probably are, it's easy at that point to make sure, if you don't have it, to get the assignments in place. It's a whole other thing to do it when you're letting somebody go and they think they were mistreated. So, understanding talent as its impact to the patent poison pill is really important. And we couldn't say more about the diligence, but and how investors should do diligence and all the rest. But part of the due diligence process by investors in early stage is to interview the whole company rather than just the CEO. A lot of investors make the assumption that they interview the management team and they don't want to deal with the employees. But I will tell you, kind of an all hands meeting to meet everybody first might create some red flags for the investors. And I've seen this happen with several of my investments where the investors wanted to fly in and meet the entire team. I thought that was a great opportunity for me. I've had CEOs think, no way do I want them to meet the entire team because I don't want to be end-rounded around me. But having the investors in and the investors to due diligence for the entire team, at least for one point, Because investors who are, good at what they do have a sharp eye for recognizing problems and talents with people. So just in a cup of coffee session, round table, they can very quickly learn there could be some red flags. And recognizing that the CEO's antidote to the poison pill is really a management issue, how they handle it. And so having proper training of CEOs for intellectual property issues is a vital future plan for investors. And investors may ask after their or through a financing about the education that the CEO has on intellectual property issues. And one of the things is that when we start to look at the future of the poison pill issue, it goes beyond just employees. We mentioned it goes with NDAs, with partners or consultants. It could even go to customers. It could go to strategic relationships. So the idea here is planning for the future, that you build in this thinking of patent poison pill into all areas of the business. And recognize here that one of the things is that diplomacy becomes an important aspect. It would be always good for the board or CEO to have somebody in their set of experts. I mean, we all have our support areas, right? CEO would have their HR person or their attorney, or might have a financial advisor to the company if they don't have a CFO. Well, think about bringing in some sort of diplomacy, negotiation person that's a generalist that would help with that, would help with these issues that come up. Many times an HR director or an HR person bringing in early can help you avoid a lot of these issues. And then finally, making sure you stay ahead of this to see potential problems, even when you get the policies in place, to make this a quarterly effort to think about it at least every 6 months to make sure that something doesn't happen. It's so hard to get a company to be successful. So few make it. And then those companies that start to make it, it's so hard for me to watch that all of a sudden they're not getting the raise of money because of some patent poison pill out there. It's so hard given that the solutions to these problems are so easy with the education. And I'm not sure, I haven't gone to business school. I'm not sure that business schools teach this, but there's a significant number of early stage companies that don't make it for the patent because of the patent poison pill. So please take heed. And finally, think about hiring some expert in the area that knows about this, in the sense of, especially if it's happening, to come up with creative strategies as well. So let's wrap up. In topic number 1, we talked about the background of the poison pill. We talked about how patents are much more than just protection and legal defenses, even more than just licensing, etc. They're really there to give you the ability to raise value, acquisition value, or do raise of money. However, recognize, as we talked about in topic number 1, this patent poison pill can affect all that. It can affect legal, marketing, product. It can erode investors' confidence. We talked about the narrative that effective patent management here can really help. And we talked about 3 case studies of the CEO not even recognizing what inventorship was, or the CEO not having assignments and telling the board they're not assigned. We talked about these various case studies, and every one of them is unique, I can tell you. In topic number 2, going more deeply in the case studies, we talked about specific things where the CEO actually assumed that they knew what inventorship was. That's really an error. We also talked about how when a board gets involved to understand the rights of an inventor, that they also should understand inventorships. We talked about the case studies whereby the CTO gets let go and they file patents. So not having proper assignments can hurt even after the fact. And topic number 3, patent management challenges. So it really does come down to management challenges and how they can effectively manage the issues here. So we talked about early stage companies, the common pitfalls they make, but also how they neglect having certain diligence in place with adequate legal counsels. We talked about how costly it is to have these patent poison pill issues happen. We talked about startups erroring to have founders have a shake hand agreement, thinking that that was enough. We talked about how these future ownership issues can wreak havoc on the company. So patent management challenges, additionally, we talked about things like non-disclosure agreements and how to use those. We talked about remembering the first to file rule for patents, that is first to the patent office. We also talked about these generic assignment forms and to not just copy them off the web, because every company is very different, and having this done right by proper legal instruction is important. In topic number 4, we talked about strategies to manage these disputes. And here we talked about the different roles and responsibilities. We talked about how the board may behave and how the CEO may behave, how the CTOs and inventors may behave. We talked about solid IP governance. We talked about doing it routinely. We talked about also making sure that the roles in dealing with this get synchronized together. We even talked about how this is holistic, that it goes beyond even the board. It could go into the stakeholders and shareholders. So getting your act together right. And we also talked about not making immediate decisions, bringing together sort of a mediator and having a very holistic approach. Which then moved to very specific strategies in topic number 5 for ways to fix the poison pill problem if it happens. We talked about all sorts of ways to do this. So the holistic approach by understanding maybe you could change the product, or maybe you could get the inventor to tell you what claims he made a contribution to and mitigate those claims or eliminate them. We talked about inventing around, and we talked about all sorts of creative ways to resolve the issue. Maybe it's a mediator and just a listening ear. So all these ways are ways of dealing with the poison pill. We also said that in general, every situation is unique. So we have to think about that. And finally, in topic number 6, future considerations, we discussed how this is very dynamic in a startup. We discussed how effective patent management is really key, obviously, but in the future, we want to think about all sorts of things that we can do holistically. Everything from, having assignments and NDAs, of course, holistic issues to get around the poison pill scenario. Talked about having good advisors like HR, legal issues. We even talked about, being very inventive to sort of invent around these problems in the product or the next patents. It'd be great to take a poison pill issue off the table by just giving them the patents, say we don't need them. That's one way to resolve the issue, if you could do that. Then we talked about how you can, board members and investors can use this as a way to try to foresee and have policies inside the company, and then to do this routinely. Even talking about investors who might come and sort of meet the whole team before the investment. So we've hoped this snapshot on poison pill helps. Really and sincerely, as a CEO myself, and seeing this in so many of my clients, and just watching the havoc this issue has, you don't even think about it, right? You think about patents and you think about litigation. Think about patents, and for some, they think about this is going to help me raise money. Who would have thought about patents and it could decimate my company? And it happens. It's like one of the biggest risks that I see in early stage tech companies. So please listen again to this podcast if you have to. Don't get into the poison pill trap. And if you like this, it'd be great to subscribe and like, and come join us in a blog, Invent Anything, and listen to our new series to Inventors at Work. This is John Cronin, Invent Anything.